I'm going to talk a little bit generally about the FTC CARS Rule. It has 4 general main requirements, but as most people also know by now, the FTC has stayed enforcement of the CARS Rule in response to a petition for review filed in federal court by your NADA. The original enforcement date was this coming July of this year. Now enforcement is tabled. As mentioned, there are 4 main categories of requirements under the CARS Rule. The first primary section lists prohibited misrepresentations. You may ask yourself, they're misrepresentations, aren't they already prohibited? Yes, they are. There are 16 specific misrepresentations listed out in the CARS Rule. What dealers need to understand is the purpose for this part of the rule. It's so that the FTC, if they were to go straight to court, they can seek immediate penalties against dealers for engaging in those misrepresentations. The second part of the rule lists required disclosures. A few of those are minor requirements that you're probably already doing in your paperwork. If a voluntary protection product is not required, you have to disclose that. I think most dealers are doing that already. If you're discussing monthly payments potentially with a purchaser or a lessee, you have to disclose whether that will result in higher long-term payments for the customer. And I think most of you are doing that as well. The primary new disclosure item is listing an offering price with capital O and a capital P. And the FTC defines offering price under the rule as the cash price that any customer can purchase the car for, excluding only government fees, mandatory government fees. So what does that mean? That's going to require changes to advertising. Dealers are not going to be able to have fine print or asterisks or tack on other fees down the road. It's all going to be right there in the offering price in your advertising and in dealers' initial responses to consumers' inquiries about a specific car. The third primary section of the CARS Rule is, the FTC calls it the dealer charges for add-ons and other items. Add-ons being the FTC's term for VPP items. So there are 2 primary components to that section of the rule. One is that VPP or add-ons that convey no benefit to the consumer are illegal under this rule. There's a lot of ambiguity there. Nobody knows exactly what that's going to mean. It's clear that some of the examples set forth by the FTC include selling nitrogen in tires where there's no more nitrogen than in the ordinary atmosphere, selling gap products that don't provide coverage for the vehicle or for the area where the consumer lives, things of that nature. But beyond that, it's hard to say what the FTC is getting at with that part of the rule. And the other component of that part of the rule is the requirement that dealers cannot sell any item to the consumer without attaining the consumer's express informed consent. Again, however, that's an ambiguous definition. Express informed consent must be near and proximate location to a clear and conspicuous disclosure. But interestingly enough, the FTC says, what does not constitute express informed consent? A signed or initial document by itself is one of the examples given by the FTC in the rule as to what does not constitute express informed consent. So that's not very clear, is it? The FTC in its 350-page commentary suggests that that might mean you simply need to have the express informed consent signed off on in close proximity to the clear and conspicuous disclosure. It might mean that you just can't create confusion or an atmosphere of deception, some nebulous terms found in the FTC commentary. But ultimately, we don't know exactly what that's going to mean. And the fourth primary new requirement in the CARS Rule is that dealers must keep records for 2 years, basically of all of their compliance with this rule, including records that they provided training to their employees to demonstrate that they have a compliance program in support of the CARS Rule. So given all of those elements of the CARS Rule, and given that they're now on hold, we don't know when this is going to become effective. As mentioned, the NADA had requested expedited review from the Fifth Circuit Court of Appeals. Given that the FTC has already voluntarily stayed enforcement, I'm a little skeptical that the Court of Appeals is going to issue any kind of expedited treatment to the rule. So I would be very surprised if anything gets resolved on the rule this year. Well, what can dealers do in the meantime? I think I would recommend that dealers begin thinking strategically about their eventual compliance with this rule if it does come down the pike. Primarily, what will you have to change in your advertising in order to meet the offering price requirement? What are you going to have to change with your record keeping? What will you have to change with your training, both as to sales and as to compliance with this rule in general? And if dealers are not already disclosing their document fees and other add-on fees of that nature in advertising, you need to do that anyways.